So before we move on to biotechnology and patents and association, I'm just going to more or less just kind of like a small summary on other IP rights. So it could be in various forms and subjects to associated or various kind of IP such as performer rights in performance and recordings, trade secrets under confidential agreements, database right for certain types of databases, and for some of you as MBB, you're going to be learning on some of the databases. So there are some databases right there. Semiconductor topographies. So do you know that the maps and the topographies of so usually topography applies to maps, but topographies of a lot of other geometrical condition is also under IP rights. We have plant breeders' rights. We have geographical indication of origin. We have conditional access technology. We also have publication right and a whole lot more. So these are some of the other IP rights commonly used as well, apart from the 4 major IPs. Now, in Malaysia, we have one body that basically monitors and for you to register any one of your patent, trademark, or design or copyright. And they even have two other IP over here, geographical indication and IC layout design. So if you were to go into MyIPO, so this is myipo.gov.my. So this is the official portal of Intellectual Property Corporation of Malaysia, or MyIPO. So they are based in Kuala Lumpur. They are the one that monitor and anything that you need to register, either copyright or trademark or industrial design or patent or geographical indication and IC designs. Okay, you need to go through this website. Right. Apart from that, because if you were to go through this, fine. You save a bit of money, but it will take you longer because they would have to process it based on the filing number. So if you were on the list or on queue of 130, so you have to wait until the first early parts is finished, and only they will come to your application. If you were to hire a private company such as this, Nurul Doha Sdn Bhd, there are other companies apart from Nurul Doha. I'm kind of like promoting. This is my friend, my coursemate from undergrad actually. So she has a company which basically more or less kind of like a middleman or middle person that would help you in registering your patent or trademark or industrial design. Only these three, not copyright. They don't handle copyright. So because copyright is actually much easy, but patent, trademark, industrial design takes a long time because you have to do some search before it could be registered. So they could do that for you at a certain fee. Don't ask me what the fee is. You just need to find out, because I'm not going to say the fee because it depends on the type of IP, the type of protection required, and what are you going to offer from there. Okay, so this is actually one of the company. If you were to Google private IP companies in Malaysia, there are a whole lot more. But this is I've actually engaged. We have actually me and my team previously have actually engaged their service, and they are very good. Even though it is quite high, I could understand why they charge us quite high, even though that was in early 2000. But still, because it's not easy. Even if you were to do it yourself, probably you reduce the cost, but you have to wait a longer time. When we use their service, it's actually lesser time, but of course higher cost. So there are pros and cons there. But if you are not so good in terms of filling up all the forms, because over here in either you want to register a patent, trademark, design, or any one of this, okay, the form is actually very confusing, very tedious process of filling up the forms, especially for patent. So it's quite confusing, and they actually could do that for you. So to us, paying that sum of money is actually quite satisfying, so we don't really have to have a headache of filling up the forms. Alright, so like I said, just to recap or a brief or small summary. So these are some of the signs you would normally see. Okay, we have copyright, we have registered trademark, TM, and also service mark. Okay, we also have the most commonly used in Malaysia as well, plant breeders, design, geographical indication, and patent, which doesn't really have a sign. Alright, so I'm just going to continue from the summary to how could you enforce the rights for any kind of the IP, not just the 4 that I mentioned, probably some other IP that apart from the 4 that we have discussed. So first and foremost, you have to know that it is the private rights of owner or owners. So legal action could be taken for a breach of rights. So to reduce illegal use of IP, it is advisable to inform notification of IP to other people so that they know it has been protected, it has been registered, so they don't use it. Because if they use it, if you want to sue them, they would say that they don't know because there is no notification. A part of it is not their fault. Okay, so you need to have a notification as well. In Malaysia, IP is maintained by a tribunal appointed by the minister to consider and approve application for license to produce and publish by the MyIPO, arbitrate disputes relating to the licensing by licensing bodies. So matters regarding IP that contradicts with the tribunal may be appealed to the High Court, and well, a few people have gone there for this kind of dispute. So another option is to issue a policy for the IP. It would protect you more, but it would be a bit more tedious because a policy is not easy to produce. So how do you use an IP? You need to get permission. So in most cases, you have to ask the owner if you want to use their IP. Some users are, however, not restricted by IP, for example, an IP to be used as a source of technical information. But if it is a process, for example, especially if it has been published and it's stated there that it is in the process of patent filing, so you need to be very careful. You need to ask their permission. In certain cases, certain owners are very helpful, very generous. They will let you use some of it, not all. And of course, they don't really tell you everything about the steps, but they would tell you some of it. So for copyright, exception for photocopying for non-commercial research or private study, public performance by non-profit clubs or institutions for charitable or education purposes, and no administration fee is actually charged. So the exception is those, okay, that I have stated again for this. Alright. So such cases for copyright again requires permission and can be exempted from paying royalties. So if permission has been refused, so if you ask and the owner or the person with the copyright says no, so IP may be used by getting a license or payment, which means that you need to come to a term with them. You need to settle it down if you are really hard or if you really want to use their technology or the IP, their IP. So protection and the benefit. Of course, you have to apply for protection. If you don't apply, then if anything happens, then not a lot of things could be done. And it also depends on whether it could be protected or not. So patents and trademarks have to be registered for protection. And unregistered IP with automatic protection are usually only copyright, design rights, and formal rights. So protection for a material can be covered by more than one type of IP, as you have seen from the clothing design from Liana Rahman just now. It was protected by copyright and also trademark. So different IP rights offer protection in different ways, as you have seen earlier on. So it is advisable to apply IP ASAP, as soon as possible, as disclosure to public with application will be rejected. If they basically, for example, Liana Rahman just now, if they even just put it up in their IG before they register, it will be rejected. So that's why they need to get the number for registration number first before they could put it for marketing. So the benefit or exploitation of IP depend on owner's intention of use. So if a material could benefit others, owner may license its use for other people, such as in the case of J.K. Rowling. And there are certain restrictions in a few areas of IP that does not allow the rule. For example, if it is something to do with government or trademark secret. So IP can also be sold to gain its benefit, such as in the case of the J.R.R. Tolkien, whereby the heir actually has sold the right, but owner, we have to be very careful, or the heir will lose his or her rights on the material and need to obtain permission from new owner if they now want to use it. Okay, so think about it wisely. Alright, so I'll just leave you to that, and next week we're going to have a look at biotechnology and patent.